We received an email from Lishan. According to Lishan, her grandmother bought a lot that was mortgaged with the bank. In the deed of sale, it was stated that her grandmother shall assume the mortgage and/or obligations attached to the lot. Recently, her grandparents were looking for the deed of sale as they wanted to redeem it. Meanwhile, Lishan has a cousin who claims that she was able to find their grandmother's document at the central bank and bought the property. According to Lishan, her grandmother was not notified of the sale of the land to her cousin. Lishan also mentioned that her grandmother executed a document stating that she will bequeath the portion of the lot where Lishan had built her house to her. At present, however, her cousin wanted to eject them from the lot and told her that if they do not voluntarily leave, she will have Lishan's house demolished and/or burned. Lishan wants to know whether the central bank can sell the property to her cousin without any notice to her grandmother. Can her cousin cause her house to be demolished when her house is made of concrete? Can her cousin pay for the value of her house? Lishan, the BSP's primary responsibility is to provide policy direction in the areas of money, banking, and credit. It supervises operations of banks and exercises regulatory powers over non-bank financial institutions with quasi-banking functions. It is hardly believable that your cousin will be able to redeem your grandmother's foreclosed property at the BSP itself. Redemption may be made and coursed through the bank with which your grandmother had executed the mortgage. Assuming that your cousin was able to buy or redeem the lot over which your house was built, he or she may demand to eject you therefrom after payment of the value of the house you have built, or allow you to rent the portion of the land where your house was built, or sell you the portion of land where your house was built. According to Article 448 of the Civil Code, the owner of the land on which anything has been built, sown, or planted in good faith shall have the right to appropriate as his own the works, sowing, or planting, after payment of the indemnity provided for in Articles 546 and 548, or to oblige the one who built or planted to pay the price of the land and the one who sowed the proper rent. However, the builder or planter cannot be obliged to buy the land if its value is considerably more than that of the building or trees. In such case, he shall pay reasonable rent if the owner of the land does not choose to appropriate the building or trees after proper indemnity. The parties shall agree upon the terms of the lease, and in case of disagreement, the court shall fix the terms thereof. Be reminded that our opinion is based solely on the information you provided us and may change depending on any additional information. You are free to consult a lawyer of your choice regarding your legal concerns. Email us at ptv4newscenter@gmail.com. Attorney J.J. Jimeno-Atienza for the Rule of Law.